Good morning, everyone. Good afternoon. We'll give everyone a few seconds to join, and then we'll get started. Well, thank you very much for joining us for today's webinar as part of our Denton's in-house counsel CLE webinar series. Today, we're going to be talking about privacy and cybersecurity rules that are impacting employers as part of our ongoing advanced technologies in the workplace series. Before we get started with introductions and a little bit about our discussion today, we do have just a few housekeeping notes to take care of. For the benefit of all participants, attendee lines have been muted. So if you do have any questions during our presentation, and we encourage you to submit them, you can submit them through the question and answer box in your Zoom interface, and we'll try to answer those questions throughout. If we can't address your questions during the webinar or after, we'll certainly follow up after the program. Today's webinar is also being recorded and will be circulated to all registrants via email after the event. So if you do have any follow-up questions at that time, you can reach out to any of us or the key contacts in the email to find out. Denton's can only issue CLE credit for attendance during the live broadcast of the webinar. So participation in this live webinar must be on a computer or laptop device. Credit will not be available if you join via a mobile device. And one other important note before we get started, if you have a New York, New Jersey, Pennsylvania, or Kansas license, please be sure to listen for the code word given during the program. When you're prompted, you'll need to enter the code word into the Q&A box. And if you don't have a license in these states, you can ignore us for a few minutes and then rejoin after. So with that, we just wanted to do some brief introductions before we get into the program. My name is Peter Stockberger. I'm the managing partner of the San Diego office, and I work closely with Joe Allen and Carl in the employment group. My focus is both on employment and data privacy, cybersecurity, and AI. So I work with employers all over the world on navigating this intersection between employment and privacy law. And excited for Joe Allen and Carl to join me today. Joe Allen, I'll toss it over to you for a brief introduction.
Hey, everyone. My name is Joellen Whitney. I'm a shareholder here at Denton's Davis Brown in the heartland, so not anywhere near Sacramento or San Diego or any of those other places. And I do a lot of work with highly regulated industries like healthcare, telecommunications, finance, that kind of thing. So I do labor and employment, and then I do privacy and security as well.
All right, Carl, how about yourself?
Yeah, so my name is Paul Lehman. I'm an associate in the Denton's Labor and Employment Practice Group out of the San Diego office. And my practice primarily focuses on counseling California and national employers on kind of day-to-day compliance with employment law, and also defending employers in employment litigation.
Terrific. So a little bit about what we're going to talk about today. We're going to be running through what we see are the critical privacy and cybersecurity legal issues facing employers. We're going to kick things off with Joe Allen talking about some of the more traditional medical and confidentiality issues that have faced employers for years. And then we're going to turn to some of the newer developments that are really impacting employers, things like the California Consumer Privacy Act, these omnibus data privacy laws, and then also issues around workplace surveillance and biometrics. So a little bit of the old, a little bit of the new, and hopefully give you a comprehensive view of some of the challenges that are facing employers in today's environment. So with that, Joe Allen, I thought maybe you could kick us off, because I know you've got just such extensive experience working with clients across industry on some of these thorny issues around confidentiality, healthcare, and a lot of new laws that seemingly sort of pierce into that traditional matrix. So I'll toss it over to you.
Thanks so much. I appreciate it. So really, I think the issue that we have on a lot of this is that a lot of what we're looking at is some very traditional laws you've talked about, but also some pretty significant changes for those kinds of things. So I think my job today is really to talk about that foundation, the base of the privacy issues that we have. But the thing is that that base is really very complicated. So We have a pretty complex base of everything that is occurring here. And what applies to you and the issues that you have really can vary by industry. They can vary by the size of your company, your locations, because we have a lot of state variation, types of programs you offer, and even your employee demographic can all affect the privacy rules, the data you collect, all of those types of things. We also have these overarching federal rules, so we always need to be thinking about industry specific. We need to be thinking about your location, but you also need to be thinking about these big generalized rules that impact upon us. The thing I always want to sort of emphasize with people is this really needs to be a pre-hire to fire process. You need to be thinking about confidentiality before we hire people, all the way through when they leave employment or where we're terminating them from employment. As I indicated before, I work a lot in highly regulated industries like healthcare and finance, telecommunications, food production, that kind of stuff. And so when we talk about healthcare, we're looking at HIPAA and high tech. Depending on your industry, we might be looking at Part 2 rules, which relate to substance abuse programs, but we could also be looking at CMS issues in healthcare. But outside of that, you could have the red flag rules, you could have state-based privacy issues, we can have the PROTECT Act when we look at children. The list for finance, I know that both Carl and Peter are going to talk a little bit about that. That could take all day, right? You know, just sort of talking about those issues could take all day. If you use a lot of foreign workers, we may have DOJ involvement. That's something where I'm going to get my immigration group involved in that, who's chaired by Lori Chesser. And you have alphabet soup, right? We have the Office of Civil Rights. We have the Office of the National Coordinator, the FTC, the FCC, you have CMS, you have the Department of Justice, all of whom relate to these sort of healthcare kinds of issues. The things that are common to all of us are going to be the ADA and the ADAAA. It's going to be the FMLA, state laws relating to how we collect that information. You're going to have a lot, right? I'm not sure we always think about how much information we have. We have bank account numbers, we have credit card numbers. You have a lot of tax data. Okay, you have a lot of data for that, but you have this enormous amount of healthcare data that you might see, right? And that we might have. So the first place is going to be work comp. If you have a lot of work comp, and frankly, it doesn't really matter what industry you are. It doesn't matter where somebody bent over or tripped over, something, or they got injured in a trucking accident, you're going to have work comp. So if you have work comp, that's not HIPAA, right? Because you're not going to be treated as a covered entity for the purposes of work comp. But you are going to have state-based rules under your workers' compensation statutes that relate to how you manage that data, who you can share it with, and the sort of fencing you have to put in place to manage that. You will also want to check with your carrier, because different work comp carriers sometimes have different rules about privacy, about how it's used, about what we do, right? So work comp, not HIPAA, going to be state-based and also carrier-based. And so that's, a box to check when you're doing this, is to look through those kinds of things, because again, that's a lot of highly confidential health data that even when you're not a covered entity under HIPAA is going to carry a lot of weight with it. If you are an employer-sponsored health plan, then that's likely going to implicate HIPAA. Employer-sponsored health plans can be fairly broad. That could be an industry that's managing its own health insurance. Maybe you're self-insured fully. But it can also be when say your health insurance plan is done by a larger or a major company, but you manage your own short-term disability, or you have an internal long-term disability plan, or you're managing those kinds of things. If you are managing insurance where you are getting physician notes, you're getting reports, you're doing those kinds of things, you're getting pharmacy, right? You're getting what we call med-rec documents, so medical reconciliation or pharmacy reconciliation documents, those kinds of things, then it's going to be HIPAA. And as an employer, either you're going to have to create broad HIPAA policies, or you're going to have to carve out a group where those people are going to get HIPAA training. You're going to have HIPAA policies for them. You're going to have a notice of privacy practices as it relates to that when you have these sponsored health plans, whether that's more generalized insurance, or we're talking, again, short-term or long-term disability. The thing not to forget there that a lot of big healthcare entities sometimes forget is that you have to have policies on amendment of the data, on access, on data breach, and you have to know employees have to know who they go to when they have a complaint or a problem when it's HIPAA related, okay? You have employee requests for leave and accommodation. That most frequently is going to be the ADA, the FMLA, maybe a state-based rule on the ADA or FMLA. Most of those statutes are going to require you to have the ability to audit those records and to be able to show who has accessed them and why. Because remember, under the Americans with Disabilities Act and under the FMLA, how you share that information internally to your organization is going to be limited, right? When we look at the FMLA, you can't just bring the entire team in and tell them what's wrong or why somebody is going to be gone. When we do look at the ADA, you can't bring everybody in to discuss somebody's disability, their healthcare need. There's going to be limitations on that. Your human resources group, or maybe your ADA or FMLA management group, is going to have some limitations there. They're going to need some special training in how that information is conveyed. A lot of times when I'm talking about those employee requests and how that's shared with the team, we're also talking about developing a communications plan, because remember, all these rules are rules of notice and consent. And so when you have consent to communicate to a broader team, that type of thing about ADA accommodations, about FMLA, and we get that recorded, you're going to be able to do more of that with your group. Okay, so you're going to have that FMLA, the ADA, those types of things that you're going to have. Now, if any of you happen to work for educational institutions and you have student workers, we're also going to layer FERPA onto that. And we're going to have those FERPA issues that we need to address and we need to think about. Employee health tracking has also been a very big thing. But here's the thing, got a huge amount of attention during COVID, right? All we did was talk about employee health tracking and who we're going to call and what we're going to do. And I must have seen 10,000 forms when we were doing this. But in a lot of instances, we've always tracked employee health, right? If you're in an industry like manufacturing, we got to track hearing, right? We have to track hearing for OSHA. We have other things that we have to track. I do a lot of work in healthcare. We always track infectious disease, right? We always track HIV/AIDS exposures. We always track those things because those things are also going to be subject to these privacy rules. And you need to remember that state laws, when we are doing employee tracking, may differ from federal law. So maybe you have federal OSHA, right? And you're going to deal with that, but maybe your state, I mean, and I know Peter California has all its own rules, right? Every agency, everything you have there. So they're going to have their own rules. Where I'm in Iowa, we basically just use the federal rules, but that's not going to be true everywhere. If you have information that relates to hearing, that's not going to be subject to the same levels of confidentiality as if you're getting blood testing information for HIV/AIDS, right? Or other kinds of things. So you're going to have complexity with that. And remember, that goes back to your industry, and that goes back to location, and it also goes back to size, okay? And the other thing I want to talk about briefly, sort of attached to that, is employee physicals. A lot of industries use employee physicals. If you're in trucking, manufacturing, healthcare, right? The healthcare ones are typically going to be mandated by state law. We're going to have these employee physicals. Employee physicals, again, if you have HIV/AIDS information, that kind of stuff, it's going to be subject to a higher level of confidentiality. You're going to need to put in place some things that you use to manage that internally, and your training for your employees who access that data will change because you'll have more than one level of things you have to talk about. But the other thing to think about, particularly with those employee physicals, particularly pre-employment ones, is genetic information under GINA. Okay, so you have GINA generally, and then you have an entire section under the HITECH Act in HIPAA that governs this use of genetic information. One of the problems that we sometimes see with these employee physicals is that they are overbroad. Sometimes they're overbroad because you accidentally asked for it. Sometimes they're overbroad because you're working with a new company or a new provider and they don't understand the real function and nature of an employee physical. But you get a lot of data about people's family history of high blood pressure, people's family history of breast cancer, people's family history. Problem with family history is all of that family history is considered genetics. And you don't get genetics as an employer. We're not allowed to ask for it. We're not allowed to keep it. We're not allowed to use it. And so you want to make sure that when you go into a new relationship or you're using new providers, we've had that discussion. So we're not getting the excess information. The other thing, remember, thinking about this from hire to termination, right? Hire to fire, is build into the policies statements that we don't ask for genetic information. We don't use genetic information. We don't store it. You do not want the responsibility of storing the genetic information because that's a whole nother framework. We don't store it. So with my employers, we put that into our FMLA policies that we don't request or keep genetic information. Like I said, I have a lot of industries that use pre-employment physicals and also either like every 2 years or every 4-year physicals. We put in there that we don't accept, keep or store genetic information. You want this to be reflected in every step of the process, that the confidentiality is there and it's reflected in every step of the process. When we look at this health information, you also need to be thinking about your third-party vendors, because a lot of you will have third-party vendors who are managing this data, and you have payroll companies that manage your FMLA, you have third-party administrators, and you need to think about what those contracts look like. Have you done your due diligence to determine if those third-party vendors have security and privacy measures in place? Do you require that they do training, right? This is all your checklist, right? Do you require that they do training? Do you require that they provide you timely notice of a breach? I know that I've had a number of clients whose payroll companies have had data breaches this year. I've had a number of clients whose FMLA management companies have had data breaches. Insurance is always a target, right? When that kind of thing, because there's a lot of data stored there. And so we want to look at that. The other thing that I would like you to think about, right, is that I also want us to take note of broader changes in the legal environment that aren't really exclusively related to privacy, right? So we have the FTC proposed regulations that would basically end non-competes, except in very specific instances. We have the NLRB assertively, right, expanding Section 7 rights. And the NLRB issues with that. Jennifer Abruzzo, Chief Counsel for the NLRB, has a couple of memos out that go not only to these non-compete agreements, but also to agreements on confidentiality, things on non-disparagement. And that creates an uncertain environment for us, because I know that a lot of industries have really relied on these contractual agreements to protect their data, to protect health data, to protect all of it. But we're in this uncertain environment, and it's putting a lot more focus on us keeping our data locked down and sort of reiterating that those issues. Sometimes when I talk to people about the healthcare data, we don't really think of that in the same way that we think of our trade secrets, right? Or our proprietary and confidential information. We're not always thinking about it kind of in the same bucket. But the thing is employees can access and use healthcare data from other employees in ways that can damage your business as a whole, okay? I have had employees use the fact that people were in substance abuse counseling, that people were getting treatment, that people had cancer. When they left, they took data with them and used that to try to leverage clients to say, this person won't be around, they're gonna be gone, they can't service your clients, right? So you have those issues. I've had people access payroll advance data. We've had a lot of my clients have emergency funds where you can apply for emergency funds. I've had people access that kind of thing and then hand it over in a divorce proceeding, right? So you really do, even though we mostly tend to think about trade secrets, all this healthcare data, all this other data can be leveraged, depending on how, nefarious or diabolical the exiting employee is, can be leveraged in a way that can be very damaging to your business. And so you do want to make sure that you put those things in place and that you lock that data down. Divorce issues, right, can really make enemies of your employees. That's one of the last things we talk about sometimes. They really can make enemies of just internally when people give data out, when they give it to other people. You have the divorce proceeding issues. And so you want to make sure that when you're doing your training, that you talk about that, right? That you talk about, if you work with this data, you have access to it. You're not allowed to share it. Even if your best friend is now divorcing your coworker, you're not allowed to share that data, okay? That you have to be careful about those things. And we have to have the ability to audit and see who has accessed it. If you are HIPAA covered, real-time auditing is required by law. You have to be able to audit, but you will also see that utilized by the FTC. You will see it utilized by other entities and other places about that. The other thing is that we've talked a little bit about third-party vendors, and third-party vendors is very complex when you are talking about using a third-party vendor like an app for your employee health data, right? So I am seeing a lot of what I think of as bespoke apps, right? Apps that are designed for your company to help employees manage their healthcare issues. Maybe it's managing weight or diabetes. I see a lot that are intended to help people manage, pharmacy costs, those kinds of things. See a lot of wellness apps, right? Wellness apps are really popular and that kind of thing. But the problem that we're going to have with those is that's going to start to creep in to some of these other areas like HIPAA. So you have the Office of Civil Rights who manages HIPAA, right? They enforce it, they manage it along with the Office of the National Coordinator. They do the HIPAA work, but you also have the FTC involved in that, right? You have the FTC and they partner with the OCR to do a lot of this healthcare data. And the FTC and the OCR together are pretty aggressively going after these application-based breaches or what they consider breaches. And if you have a bespoke app, right, particularly one that's either maybe just tweaked for you, not exclusively designed for you, but maybe tweak a bigger app that's tweaked for you, or which is housed on a bigger platform, right? We're starting to see some pushback on those. We're starting to see some issues with those. A lot of that is not having good terms of use, particularly when you're asking people to use these apps or you're giving them, let's say, a $500 credit to health insurance to use them. We're going to run into some wellness rules, but you're also going to run into these FTC rules. The problem is when the app itself isn't secure. Okay. A lot of times there's problems when we claim they're secure, but they are in fact not doing the encryption or not doing something. So that again goes back to your due diligence with your healthcare providers. And then again, if you're housed on a bigger platform, that kind of thing, we've seen a lot of issues, including ones that are just more generally commercially available apps. We see a lot of issues with them using that data to then target advertising for you. The FTC just in the last year, they had settlement agreements with GoodRx, with Good Health, with a number of other larger apps that are used by the public with this sort of targeted advertising. But we're also seeing some of these smaller cases and some, sort of desk audits going out to companies that have these bespoke apps. Can I have the next one, Peter?
Joellen, real quick on that, on the app issue, one thing that OCR is focused on right now as well is the use of third-party cookies within these apps.
Yeah.
And saying basically, like, if your employee is using this app, and let's say your employee goes to a website to look up a medical condition, and you have control over the third-party cookies that are placed on that, IP address, click data, that's actually going to be considered PHI under HIPAA. And so
Right.
do you have a BAA in place with that third-party cookie provider? So to your point, Joellen, that whole area of digital application, digital health engagement with your employees is wildly complex right now and requires, just to your point, diligence, planning, looking at those vendor contracts. That's sort of the secret sauce in preparing for that.
Well, and Peter, just to add to that, one of the things that I didn't address, because I'm trying to be cognizant of my time here, right? But one of the things I didn't address is what are called the information blocking rules, right? So under the 21st Century Cures Act, we have this thing called the information blocking rules, which is meant for data to work together, right? So various systems to work together. It doesn't help us if none of the systems talk to each other. But what we're seeing in contracts is people using that as a way to sort of leverage more open access to data, to ask for more de-identified data, those types of things. And we do have to be very careful in our contractual arrangements, particularly as you indicated with these applications, because of how much data flows back and forth and where it goes, right? We're just starting to see some of the enforcement concerns under this information blocking rule, but I do think a lot of the contracts sort of scooped that up and tried to use that as a way to access more data than, frankly, I'm comfortable with for most of my clients because of the very new nature of those rules. And also because of, I mean, again, when I said the FTC and OCR aggressively after this stuff, I mean, they are aggressively after this stuff, right? They're on steroids. This is a big deal. And they are really, really after this stuff. And so none of my clients want to be in the newspaper or on somebody's podcast. We have no interest in being in your podcast. And so we tend to be a little conservative, right, in managing data. The other thing, frankly, is that when people are afraid that their healthcare data will be breached, right? People worry about what their neighbors will think. They worry about what their boss will think. They worry about if they'll lose their insurance. And bad data privacy and security can really damage your recruitment and retention efforts, right? Because those are real fears of your employees that it's going to get shared. People are going to gossip. And so we don't have good policies. If we don't put them in place, if we don't protect the healthcare data, then we can really run into problems with recruitment and retention as well.
And I
So
think your point there, Joellen, sorry, I think the point there about making sure this entire scope of employee data around health is protected. A
Mhm.
lot of times internally, what happens is the security department that's in charge of implementing access controls and security controls in the data classification policies, they'll be focused on personally identifiable information for consumers or external resources, and that
Right,
employee component may be second tier from a security
right.
standpoint. And I think the takeaway that I have from all this incredible information you have is you can't do that. This employee data is tier one, along with consumer data from a security
Uh-huh.
standpoint. And so the HR group needs to be tied at the hip with the security group ultimately.
Well, if you have a privacy and security committee, I think you need to have an HR person on it, right? I know that you guys are going to talk about some of the other more complex things and that kind of thing, but when you look at the EEOC's algorithmic fairness, right, program, one of the things they say is that the people who design the data security policies and the software don't talk to the people who use it, right? And so that you have to have that communication, or we don't get what we need. So, and now I think, Carl, are you up next? Is that what that is?
I'm actually going to jump in now, Joellen, and pick up, which is actually a nice transition because I think a lot of what you were just talking about with regard to using data, notice consent, the security component actually ties into this sort of second category of privacy law. So those excellent job on describing the sort of core confidentiality, a lot of just day-to-day blocking and tackling on privacy. But we have these new data privacy laws that have cropped up in the past couple of years that really fit in this bucket of omnibus consumer data privacy laws. And so really that's what I'm focused on is at the state level, the development of these laws. And the primary law that impacts employers is the California Consumer Privacy Act. This law took effect in 2020. It was a first of its kind law in the US, really trying to model itself after a European approach to data privacy. And the CCPA basically says that if you're a California resident, you have certain rights over your data. You have a right to access your data, ask that it be deleted, ask that to opt out of it being sold. And the CCPA only applies to certain businesses meeting a certain threshold requirement. The CCPA has been around since 2020. It was amended this year on January 1st by this California Privacy Rights Act. So this is a law that's in effect today. We have other states. We have 12 states now with these omnibus data privacy laws. Virginia, Colorado, and Connecticut, their laws each took effect this year. Utah has a law taking effect next year. At the end of this year, we have Texas, Oregon, and Montana taking effect next year. Joellen, your state, Iowa, is coming in the following year with Indiana, and we've got Delaware and Tennessee on the radar as well. So we have 12 states total. But the good news for this group, I come bearing good early Christmas present, only California applies to employees and job applicants. The rest of the 11 states actually exempt employment-related data. So if you see the scary headlines, we've got 12 complicated privacy laws. Really, California is the one that impacts employee and job applicant data. So that's what I'm going to focus on. And I'm in California and I live and breathe the CCPA. I sleep with a copy of it under my pillow. So that's what I'll be breaking down for you. CCPA, are you a covered business? That's the number one question. Not every company is covered under the CCPA as a covered business. There's really 4 ways you can be covered. One, you have to be doing business in California. So do you even have a job applicant or an employee in California? The answer is yes. Then you look to see, do you have annual gross revenue over $25 million US? And that's measured calendar year, January to December. And that's gross global. It's not just California. If you don't hit that revenue threshold, then you look to see, are we collecting the personal information of 100,000 or more California residents annually? And when I say California residents, it's California residency as defined under the California tax code. So this can include people who are residing in California, but also people who are living in Iowa to go to college for a transient purpose, but maintain California residency. So you have to consider that in your employee count and individual consumer count. Employees and consumers are both counted for that 100,000 count. If you don't hit that, the law says if you're deriving 50% or more of your gross revenue from selling personal information, so these are data brokers, then you're covered. And you can also be covered if you have a joint venture with certain percentages, and if you're in a parent subsidiary relationship that may meet some of these thresholds. So not everybody's covered. That's question number one. You got to figure out, are you a covered business? It does apply if you are a covered business. Consumer is defined broadly to be any California resident. So this can include California employees, job applicants, or independent contractors. And the definition of covered data, personal information, is anything under the sun. It's down to just name is covered personal information. So it's any information that can identify, relate to, describe, is capable, reasonably capable of being associated with an individual or a household. Now, Joellen, this picks up on something you just mentioned about the data blocking and this increase we're seeing in sort of saying, well, let's share de-identified data with third-party apps. The CCPA excludes from personal information de-identified information. So if data is truly de-identified, it's not covered and you're free to share it. However, the catch, there's always a catch, de-identified, the definition under the CCPA is that you have to have a written agreement with that third party where they promise they will never try to re-identify it. And a lot of third-party a lot of the third parties that are in the digital ecosystem, they won't make that promise because what they do is they get your de-identified data, they match it against their data sets so they can actually identify the person. So this de-identified sometimes can be a whole thorny mess. So key takeaway there is pause, consider it before you agree to de-identification. But really the CCPA gives broad rights to consumers. So I just want to show you an example of what personal information is defined as under the statute. This is the statutory list of information that's defined as personal information. And as you can see, a number of these are just core to the employment, job applicant, HR process. And in fact, we have a provision here that says employment-related information. This can be information relating to performance reviews, anything that's associated with an individual. The last bullet point is one that causes a lot of employers headache because it's inferences drawn from the above information that creates a profile reflecting the individual's preferences, characteristics, psychological trends, predispositions. So you can see where employment reviews or comments about an employee's tendencies. I don't think this employee has enough motivation to get the job done. Well, now you are making an inference about a predisposition or behavior based on their employment-related information. That line about, I don't think that they're good, they have motivation, that could be considered personal information under the CCPA and subject to a request for access. So you can see how the CCPA can get complicated in the HR set. One other definition I think is important here is the CCPA defines sensitive personal information and has particular restrictions around sensitive PI. Sensitive personal information can include social security number, driver's license, which is what we traditionally consider pretty highly sensitive, and financial information. It also includes precise geolocation data, which is defined as data that can track a person's location within a radius of 1,850 feet for the purpose of identifying them. So GPS monitoring, key card monitoring, all of that could potentially be considered precise geolocation data. Demographic data such as racial or ethnic origin, union membership is considered sensitive personal information under this law. Contents of an email or text, unless it's exchanged between the business and the individual, is sensitive. And information about sexual orientation, genetic information, biometric, which I know, Carl, you're going to dive into, and health information. So everything that Joellen just mentioned about health data, if it's not covered under HIPAA, because HIPAA data is exempt, if you are not under HIPAA and it's health data, it's sensitive personal information in the CCPA, and you may have heightened restrictions about what you can do with it. So again, adding layers of complexity around these various data points. So what does the CCPA give employees and job applicants? Well, it gives them these core rights. You have a right to know what data has been collected about you and how it's been used. You have a right to ask that data be corrected. You have a right to ask that data be deleted from your employer. You have a right to opt out of it being sold or shared to a third party. You have a right to exercise these rights without being discriminated against. And you have a right to not have your sensitive personal information processed for the purpose of developing a characteristic about you, which is a very unique and precise right. Now, the number one question I get from clients is, well, if somebody sends me a request to delete, do I have to delete their HR file? What if they send me a deletion request and say, delete that investigation into sexual harassment that you did a year ago? The short answer is there are so many exceptions under the right to delete that virtually you'll never delete anything so long as the person's an employee. Really, unless you've got some weird data that you're collecting. But if you have data that relates to the employment, you're largely going to be able to rely on exemption. This is really going to come into play in former employees when they come back to you years later and they say, I want you to delete my file. And that issue really comes down to data retention. How long do you need to keep records for statutes of limitation? But that's really where we see most of this. And I also am seeing these CCPA requests come up with former employees who are terminated and are preparing for litigation. And their lawyers are using the CCPA to try to get early discovery on requests for access to information. So that's a high level overview. Going back real quick, what are your obligations as a business? Well, you have a notice requirement. Joel mentioned this, or in the healthcare space, it's all about notice. It's all about being clear. Employers have a duty to notify employees and job applicants at or before the point that they collect personal information, explaining how it's going to be used, who it's going to be shared with. You have to give them a privacy policy that looks a lot like online privacy policies. So you've got these rights, disclosures. You have to have policies for responding to these requests. So there's a number of compliance obligations that get built in under the CCPA. We could spend 2 hours talking about these compliance obligations and all the thorny parts of it. But I think the key takeaway here is compliance under the CCPA is not just giving a quick privacy notice. There's a lot of layered complexity to each of these notices. Quickly on the issue of sale, because I noted there's a right to opt out of the sale or sharing. This usually doesn't come up in the employment context. Selling data is giving personal information of a California resident to a third party for money or for other valuable consideration. And so this can come into context with, for example, Google Analytics or other third parties on your website or your application. If you're sharing information with them and that third party's using it for commercial value, could be a sale. Same with sharing. Sharing is actually a narrow part of selling, and it's sharing information for cross-contextual behavioral advertising. So it really doesn't come up in the employment context. Where I've seen it come up in the employment context, online advertising tools, for example, Joellen, what you were mentioning, these increasing apps for employee engagement. Well, if you got third-party tools on those, now all of a sudden you could be triggering sale share obligations. Third-party perks providers. I had one client who was using a provider where employees' data was going to the provider was sending them like Applebee's gift cards. Turns out in the contract, that provider was saying, and by the way, we use this data to build out our own database and send these employees marketing messages. That's a sale of data. So now you have to give employees the right to opt out of that. Benefits providers who are not offering health HIPAA or GLBA finance covered data can also sometimes trip up. The exceptions here are you can get a contract in place. One, you can get the employee's consent. That's number one. Number two, if you have a contract with the third party where they promise not to commercialize the data, that can also exempt it from being a sale. So really not a common issue coming up in the employment space, but it's important to keep your eyes peeled for it. One other requirement under the CCPA that's important to flag are contract requirements. No matter who you are contracting with, benefits providers, anyone else, anyone receiving access to a California resident's personal information, there must be baseline contract provisions in place. And then if you want to make them a service provider and exempt it from sale, you have additional contract provisions needed in place. So I won't go through all the contract provisions because then everybody would fall asleep. But bottom line, every single vendor that touches your employees or job applicants' personal information, there needs to be a contract provision in place that aligns with the CCPA. A lot of the large providers out there, the ADPs, the Workdays of the world, they've already got this built into their terms. Other, I would say medium market, small market, you got to keep an eye on because sometimes these provisions will be missing. So it's a key compliance requirement under the CCPA. Real brief on enforcement, and then I'll toss it over, Carl, to you to dig in on workplace surveillance and biometrics, which overlaps with the CCPA some here. The CCPA has been enforced by the California Attorney General's Office since July 1 of 2020. We've only had a single enforcement action become public. I say become public because I've handled some enforcement actions that have not gone public. One has gone public where they announced a settlement with Sephora for $1.2 million in penalties. And that was related to their use of third-party cookies on their website. So it wasn't employment related. But we do have a new enforcement agency here in California called the California Privacy Protection Agency, which sounds like a Marvel superhero group. And it's a five-member board, and they can enforce the entirety of the CCPA. There's no right to cure anymore. They can send you a notice today, tell you to show up to the administrative hearing, and they can hit you with penalties between $2,500 per violation up to $7,500 if it's intentional. The CPPA has announced that they were focusing, well, rather the AG was focusing enforcement on large employers and employee data. The CPPA has announced that they're going to focus future regulatory activity on enhancing employee and job applicant privacy rights. So this isn't going away. And on December 8th, they're having a hearing about new regulations on cybersecurity requirements and automated decision making. So use of AI in across the CCPA. So very much a fast moving space, fast moving enforcement environment. Good news though, finally, a piece of good news is there's no private right of action. So what are my key takeaways? Look at your notices, make sure if you're covered, you've got the right privacy notices in place, update your contracts, look at your internal policies on responding to consumer requests and employees, data minimization, data retention, all core CCPA requirements. Make sure people are trained appropriately. There is a training requirement under the law. And picking up on the thread, Joe Ellen, that you threw down, don't sleep on cybersecurity. Because although there's no private right of action under this law, there is a narrow private right of action if there's a negligent data breach. So your employees and job applicants can sue you, class action, if there's a data breach of covered personal information under the CCPA. So, we're just bearers of good news around cybersecurity. Don't sleep on the cybersecurity component because it really can introduce some real risk under the CCPA. So Carl, before we jump over to your part, I do want to pause and give the code word for those who are licensed in New York, New Jersey, and Pennsylvania. Please type and submit the CLE code word in the Q&A box on the right side of the screen. And we'll just give you a second to type it in. The code word is privacy for those listening. So privacy is the code word. We'll give you a second to pop it into the Q&A. If you don't have a license in these states, you can ignore this and wait with bated breath for Carl to blow your mind on workplace surveillance. All right, with that, Carl, I will toss it over to you to dive into some of these really thorny new areas that seem to be resurging, especially around workplace surveillance and also biometrics.
Absolutely. Thank you, Peter. All right. Why don't we just skip to the next slide, Peter, if you don't mind.
Yeah. Looks like I lost control of the slide deck. Nick, I don't know if you can toss me.
I think I've got it now.
Oh, you've got it. Great.
Thank you. So as Peter mentioned, and using this handy graph, currently workplace surveillance is primarily a product of state law. And we don't have a whole lot of laws on the books quite yet, but it's an area that's like the technology is advancing quickly. And we're also seeing, in addition to state law and municipality legislation, we're also seeing federal administrative agencies take a look and focus in on the issues of workplace surveillance and biometrics. At this point, we're all likely aware of the numerous tools that are available to monitor workplace activities, particularly workplace electronic or telephone communications, but also kind of the more traditional areas of surveillance, such as audio, video recordings, productivity trackers, call recording, and then an area that we're again seeing some additional legislation, GPS tracking. And like I mentioned, there's a handful of states currently, California, New York, Connecticut, and Delaware, that all have laws on the books that touch on workplace surveillance issues. Although unlike, in the consumer privacy context, there's no state that has what I would call a comprehensive law that deals with workplace surveillance currently. And as I mentioned, NLRB, and Joellen mentioned during her presentation, the NLRB has really recently focused in on these issues of workplace surveillance, which we'll dive into a little bit more. Okay. So taking a look at New York first. New York law currently requires employers to give employees notice if they are monitoring workplace communications or employee internet usage. Specifically, the employer must notify current employees with a conspicuous notice in the workplace if they're monitoring workplace communications or internet usage. But they also have to provide new employees with express written notice of their intent to monitor activities at hire. Now, several exemptions do exist, some of which I think are quite practical, such as exemptions for monitoring kind of mass communications, emails, telephone communications, and also certain cybersecurity exemptions. Okay, and the New York currently the New York Attorney General has authority to enforce the law and can issue penalties that range depending on the frequency of the violation. Okay, taking a look at,
Carl, one
sorry.
thing about that New York law before you jump on, it's what I've seen is kind of weird. And you noted exemptions for monitoring for security purposes. That's always the thorny issue that comes up, which is, well, we do normally monitor email and telephone generally for security purposes. So, and if we're going to zero in on an employee for their email, we're doing it because we're investigating that employee for workplace inappropriate conduct or, violation of law. So do we have to provide them with a notice that we're actually monitoring their data directly? And going back to those exemptions, the law doesn't give you a clear roadmap there, but I just wanted to flag it as that seems to be the issue that comes up is our day-to-day surveillance enough to trigger notice, or does it have to be something a little bit more specific? So just wanted to throw that into the mix.
Thanks, Peter. And that also, it reminds me of something I also want to mention about New York, is that currently New York, there is a bill that's pending before the legislature in New York. It's Senate Bill 07623, which, if enacted, would provide additional restrictions on an employer's ability to monitor and use these electronic monitoring tools in the workplace. And it would specify the purposes that the monitoring tools can be used for, allowable purposes, but also requires that the monitoring must be strictly necessary to accomplish the allowed purpose. So it's currently pending before the legislature. It looks like there are some kind of powerful lobbying groups backing it. So for all you New York employers, I would keep an eye out for that law. Okay, and so Delaware and Connecticut, two of our smaller states, they have similar monitoring and notice requirements. Like in Connecticut, like in New York, you have to post a notice of the intent to monitor in a conspicuous place in the workplace. And both states, they wisely prohibit the monitoring of sensitive areas such as bathrooms or restrooms with video or audio recording devices. And this is also a rule that we see in other jurisdictions as well. Now, this California bullet point here, it's just a teaser because, as expected from the rest of this presentation, I need much more than just one bullet point to talk about California. Okay. So California law, it's like I said, it's a collection of disparate laws that all touch on workplace surveillance, even if they're not specifically targeting the employment context. So California law prohibits, like Delaware, it prohibits an employer from installing audio or video recording devices in private places like restrooms and locker rooms. Also, and I think many of us have heard of this, it's pretty well known, but California is what we call a two-party consent state, which means that under the California Penal Code, a person cannot record the conversation of another person without their consent when there's an expectation that the conversation will be private. So the classic example is most telephone conversations. But it also touches on the workplace in situations where there may be an area where there's an expectation of privacy, and if there are security cameras, and whether the security cameras are capturing audio in the workplace. I think it's also important for everyone operating outside of California to understand that the California Constitution really emphasizes and has an express right to privacy, which is actually the first article of the California Constitution. And California courts have repeatedly relied on this constitutional provision to kind of expand employee privacy rights in a number of ways. So be aware of that. Even if you think there's not a specific statute on the books, we do see breach of privacy claims under the California Constitution. And this also touches on the idea of email monitoring. There could be a potential claim, not just under the CCPA, which, like Peter said, doesn't create a private cause of action, but a claim under the California Constitution if there is some argument, depending on the circumstances, that there's a reasonable expectation of privacy in an email communication. So from a risk management standpoint, it almost always makes sense to include disclaimer language in employers' policies, provide notice of monitoring employees to employees. Okay, and this is an area, GPS tracking, which we've recently seen some additional changes in the law. So California Penal Code Section 637.7 is one of these not specific employment specific laws, but it makes it a misdemeanor to use electronic tracking devices on vehicles, except for your own vehicle. It does contain an exception if there's consent to track the vehicle. So the law in theory gives the employer some wiggle room to track a vehicle that they own themselves, but not employee owned or employee leased vehicles. But this law also changed in January of this year. I should say the law with respect to GPS monitoring changed with the Motor Vehicle Digital Number Plates Act. And it went into effect in January of this year, and it prohibits the use of alternative devices, digital license plates, but essentially tracking technology to monitor employees, except during work hours, and only if the monitoring is strictly necessary for the performance of the employee's work duties. The Act also requires very comprehensive notice be given to employees before the GPS tracking is done. And one of, I think, kind of the most interesting and the most notable notice requirement is that you have to give notice that the employee has actually the right to disable the monitoring device if the employee is allowed to use the vehicle for non-work purposes. And as Peter mentioned, GPS monitoring may also trigger the very broad requirements of the CCPA. Now, I don't want to spend too much time on the NLRB, but as we've already mentioned several times, the NLRB is increasingly focused on the idea of workplace surveillance and how it may impact an employee's protected rights under the NLRA. Generally, the standard is whether a reasonable person or a reasonable employee would conclude that the employer had placed their protected activities, their right to engage in concerted activity under the NLRA, under surveillance. And essentially, employers may not do something that gives the impression of unlawful surveillance or the impression that they're trying to surveil union or concerted activity. And this was reflected in a case that was decided earlier this year, and it's the Stern Produce case, where the employer installed a camera inside the cab of fleet vehicles, and an employee covered up the camera during a lunch break. But the NLRA said, even though that wasn't union activity, the employer still violated the NLRA because they gave the unlawful impression of surveillance. And I won't dive in. I'm sure most of you have gone to webinars about the Stericycle decision, but be aware that there's a General Counsel memo that addressed proposed legal framework for evaluating electronic management tools. And then the Stericycle decision from several months ago increase the presumption that workplace rules such as workplace surveillance may violate the NLRA. Okay, just a couple of key takeaways on workplace surveillance. Make sure to audit your policies and reserve the right to monitor workplace activities. Examine the need for legal notices depending on your jurisdiction. I think this is an easy one, but don't record in sensitive areas such as bathrooms or locker rooms. Record your employees in those areas. If you are tracking vehicles with GPS, ensure that you're following California law if you're in California, and keep an eye out for new laws being passed. We don't have a whole lot of time left, but I will just briefly mention the issue of biometrics for those of you that aren't aware. Biometrics generally refer to biological indicators that can be tracked and stored. Fingerprints, facial recognition, voice prints. Not a whole lot of legislation on it currently. Only a couple states have enacted laws. FTC has recently put out some guidance on it that may impact employers. But I think the biggest takeaway is we just see dozens of states that are considering biometric privacy laws right now. And so the law will just continue to change with respect to this regard. Okay. Do we want to wrap it up here, Peter?
Yeah, Carl, I think you nailed it on the biometrics, and we've got a couple of extra slides here giving folks a breakdown of FTC in California, and Illinois is really the ground zero on biometric lawsuits and risks. So, my always takeaway is if you're touching on biometrics, fingerprints for your timekeeping system, et cetera, be careful, look at your notice, look at your compliance. I think with the last minute we have here, and we've been answering some questions in the Q&A, but I wanted to give Joelle and Carl, you also the ability, maybe we can go around the horn and just do quick, lightning round key takeaways for folks on this webinar before we close it out. Joellen, do you want to kick things off? Oh, I think you're muted, Joellen.
Sorry. I would think that a couple of key takeaways would be what we've already said, which is that you really need to think about this holistically, about the types of data you have and what you have. To add to Carl, when I talk about employee surveillance, the first thing I want to know from my client is, what are you trying to do? Right? What's the purpose of it? What are you trying to do? What's the benefit of it? Because particularly during COVID, it exploded, right? Because you had so much remote work. But if you can't give me the business case for what you're doing with it, it's hard for us to justify that to the regulatory agency. And so that would be really those practicalities, I think.
And if I can just jump in, because I completely agree with Joellen. I like to think of rules like this. Don't think of them as just something that you plug into your handbook and forget about. They have very practical day-to-day application, and consider the risks and benefits and tailor your policies and practices to address your business's concerns, the regulatory environment, but also, the on-the-ground reality with how your employees are dealing with this information.
Yeah, no, terrific insights. And I would just say, focus on notice and talk to your counsel. That's where I would. Anyway, thank you on behalf of Joellen and Carl. Thank you very much for joining us for today's CLE webinar. I know we're out on time. Obviously, we could spend a lot of time talking about these issues. In approximately 30 business days, everyone will receive an email with a link to your CLE certificate. Your webinar login details can be used for those certificates, so no additional steps are required. And as a reminder, the code word requirement, which was privacy, is only required if you were seeking credit in Kansas, New York, New Jersey, or Pennsylvania. So with that, thank you very much for your time. We hope you enjoyed it, and we'll talk to everybody soon. Take care.
Thank you.